Would only entered executive session for the purpose of receiving legal advice, and no action was taken during executive session. The first item of business is new business. It's an administrative appeal. Before I call for the applicant, let me explain the process. It's pretty simple. When the application is called, the applicant can come forward and present their application. After the applicant, the county representative will come forward and make their presentation. We will then have a public hearing where anyone who wishes to speak for or against the application, we only have one, and you had to have signed the paper in order to speak, may come forward and speak. We do limit folks during the public hearing to 3 minutes. We will then close the public hearing, and the applicant will have an opportunity to return. And then we will have a motion from the board, discussion by the board, and a vote. So with that order being clarified, we will now move to the first order of business, the administrative appeal. Is the applicant, Mr. John Lee, present?
Yes.
If you wish to come forward. When you come forward, please state your name and address for the record.
Sure. I printed all of my prepared remarks. Can I give a copy to, just so you all have it? And then I didn't quite understand, so I'll go first, the staff will go,
Yes.
and will I get the opportunity to respond to
We will
something?
we will then have a public hearing, which we have one person that has wished to speak in public hearing.
Yeah.
At that point, if you want to come back and speak to whatever was spoken of,
Oh, okay.
then you will have that opportunity, and then we will
Great, thank you.
move on to a motion.
Can I stand? Oh, and then I guess do I just click the down or the right? Oh, okay. I can just kind of stand over here. Is that okay? Okay. So good evening. My name is John Lee, and I live at 1398 Secret Path Drive in Fort Mill. First, I'd just like to say thank you all for volunteering your time to ensure citizens are treated fairly and that our rights are considered and protected within the implementation of the zoning code by county staff. Thank you. I'd like to begin by asking this board 2 simple questions. Is there anything improper about confirming how staff is interpreting the zoning code? And shouldn't staff's primary duty be to ensure the zoning code is interpreted and applied correctly? The zoning code provides broad standing to seek formal interpretation, and tonight I will show you that my request for interpretation was improperly and arbitrarily rejected by staff. On March 18th, I submitted a records request under the zoning code's record-keeping requirements. I asked for the zoning compliance applications and approvals related to Project 2240468, which is Sofab Solar's panel and cell manufacturing facility, which is under construction at 7149 Logistics Lane in a light industrial district in Fort Mill. This project is moving forward despite this board's unanimous May 9th, 2024 decision that solar panel manufacturing is not a listed use in the zoning code and is therefore prohibited in a light industrial district. In response, I received 25 files, including construction permit applications and letters of plan review, but no zoning compliance application or an approval signed by the zoning administrator. And at that time, the zoning administrator was Rachel Groffey. I even confirmed with the county's FOIA officer that no zoning compliance application exists, providing a copy of a blank application. Sorry. This raised a serious process question. How could this project continue without a compliance approval from the zoning administrator for a new use, let alone a prohibited one? Upon reviewing the zoning code, I identified 3 non-discretionary ordinances that should have governed the situation. Contrary to staff's latest claims, which you can see for yourselves, I identified 155.262, which says zoning compliance required. It says, prior to a change in use, an applicant must receive zoning compliance approval. Oh, I'm sorry, this kind of got a little wacky. I then identified 155.1121, applicability. And that one stated, unless elsewhere exempted by this chapter, an applicant shall obtain zoning compliance approval prior to changing an existing use, constructing, adding to, or altering a building or other structure. In 155.1123, the zoning administrator shall review the zoning compliance application for compliance with this chapter. Alongside all three of those, I submitted the ordinance, and I submitted a specific question related to how this project is, how it is being interpreted related to this project. Because given the lack of a compliance documentation and the BZA's prohibition of the use, it appeared that ambiguity exists in how these provisions were being interpreted and applied. So on March 28th, I filed a formal zoning code interpretation request under 155.1092A, which permits any person to seek interpretation of any section of the code. Now, it's notable that the interpretation application is not available on the county's website alongside the other zoning forms. And that absence raises questions about accessibility and transparency in the process. My interpretation request was reviewed in person for completeness and accepted by a zoning technician. I then followed up multiple times over email and phone calls, but received no reply. Eventually, after not receiving a reply, I filed an appeal on the grounds of a constructive denial. Only after that did I learn that a response had been mailed to the wrong address due to an unfortunate clerical error. My address is 1398, and you can see here it's 1390. The rejection letter I eventually received claimed that only standards can be interpreted. And this is not supported by the inclusive language in 155.1092, which triggered this $325 appeal of an administrative decision. Even more troubling, only this past Thursday, staff has now expanded their rationale and introduced new reasons for rejecting my request, none of which were included in the original response. This expanded rationale follows an additional FOIA request of mine, which demonstrates others seeking interpretation of procedural ordinances. And these are in the exhibits I provided. It was like 150 pages. I hope you didn't kill all the trees, but I wanted to be as thorough and complete as possible. Interpretations seek clarity on ordinances. Oh, sorry. I found others seeking interpretations for clarity on ordinances that are outside of the common interpretations that are listed under the applicability, and those are in the exhibits, exhibit 1 that I provided. This after-the-fact justification of my rejection, I believe, is procedurally improper and shows the rejection was arbitrary. So I'm not the developer or an adjoining property owner. However, my home's proximity to this industrial project gives my wife and I reasonable concern, and we deserve clarity. The code provides broad standing and grants any person the right to seek interpretation precisely for this reason. Now, on June 25th, 2024, Work County Management issued an unsigned and anonymous statement suggesting that an exemption from zoning compliance exists with the statement, the decision by the BZA on May 9th did not apply to Silphal. Only the zoning code can provide an exemption. This is not discretionary. The statement cited a zoning verification letter which has no basis or process described in the zoning code. It's not in the zoning code. And 155.1095 scope of approval, which they argue shields the project. A zoning verification letter is not a defined tool under the zoning code, and it was issued by a zoning technician, which is also not a defined role in the zoning code. Zoning verifications are purely administrative. SILFAB is not even mentioned in either the application or the response. Nonetheless, the management statement asserts the letter gave SILFAB a right to develop the property for its intended purpose. Again, it got a little wacky, but the York County Vested Rights Ordinance requires Planning Commission approval of a site-specific development plan, not staff's approval. This is a Planning Commission approved vested right. The Vested Rights Ordinance also states, kind of in the bottom, it's really tiny, but it also states, no investment or other significant expenditures shall give rise to or establish a vested right until the Planning Commission has approved the site-specific development plan. And that never occurred. Civil site plans approved by staff with perplexing references and dates and zoning sections are not the same thing. And this ordinance is supported further by South Carolina law. And that's the South Carolina Naval Act. And so as for the 155.1095, which was referenced in the management statement on SILFAB Solar, it refers to any development occurring after a zoning interpretation being subject to the required, to the updated requirements. This is not referring to a project or a specific entity. Development is a verbal noun, and that's supported in the sentence prior to that bolded one. An example of a verbal noun is construction, meaning any construction that occurred following the BZA decision on May 9th must be in violation of the code as interpreted. Now, there is active construction taking place at 7149 Logistics Lane in the form of wastewater treatment facilities, chemical storage, and chemical bunkers to further a prohibited solar manufacturing use on a light industrial property. If the zoning code provides for an exemption, then so be it. There lies the ambiguity in 155.1121. If the interpretation is defensible, let it be formally stated by the zoning administrator, who is the only listed authority. In response to the staff analysis, staff have not pointed to any ordinance that prohibits my request. They only offer their opinion on what types of requests are typical. In doing so, they are potentially restricting the correct interpretation and application of the zoning code. Staff narrowly relies on the applicability section, which merely reflects common uses of interpretation to prevent my request. Yet, as shown in the FOIA examples, in Exhibit 1, interpretation requests vary widely. In my case, staff overlooks the broad, inclusive language of the full section. Staff have manufactured a prohibition that does not exist in the zoning code. Staff attempt to dictate what constitutes an ambiguity, when it becomes relevant, and who has standing to raise it. The zoning code grants that right broadly and without such limits. Ambiguity is a matter of interpretation, not discretion. And that is the very nature of ambiguity. Staff seek to gatekeep who may seek clarification, rendering a judgment on my interpretation that is outside of the scope of their duty to develop zoning code interpretations. By filtering and denying requests, staff opens the door to inconsistent treatment, increased appeals, and potential claims for bias and unequal protection under the law. Staff state that litigation around this project is occurring. That that litigation has nothing to do with me or these new errors of interpretation, seemingly using this to justify their obstruction of my right to seek interpretation. And I feel this is a red herring argument. The unanimous May 9th BZA decision is binding and stands as the governing interpretation until reversed by a court of competent jurisdiction. And just because others have sought to resolve this matter in court to protect their rights does not strip me of my right to seek interpretation. Staff make the statement that the zoning code interpretation procedure is not a vehicle to challenge the property rights of others. The statement was made without any explanation of how seeking the correct interpretation of the zoning code can possibly challenge the rights of others. The statement also clearly demonstrates staff's failure to recognize my property rights. Administrative process, including developing interpretations, requires neutrality. Staff characterized my interpretation as needless and spurious, which is degrading. And it's not the type of respectful response to an appeal of an administrative decision that a tax-paying citizen of this county deserves. Staff suggests this is a manufactured challenge, but the zoning code provides what it provides. If ambiguity exists, as it clearly does, then interpretation is the proper legal remedy. Staff manufactures new rejection rationales mid-process, conceding in their response and analysis that the prior rationale for rejection was invalid. This demonstrates the rejection is arbitrary. Please do not uphold it. Staff suggests I am challenging a past decision. I'd ask, which decision of the zoning administrator am I supposedly challenging? The June 25th, unsigned, anonymous, unappealable statement was not a decision, it was a diversion. So in conclusion, staff have now already ensured the denial and further delay of the relief I sought, which was simply to have the zoning code interpreted. Staff have restructured the substance of my appeal by stating the question before the board in this case is not what are the correct answers to the appellant's 3 questions, but rather was the rejection letter a reasonable application of the zoning code. And because of this, due notice was not provided to the parties in interest. And I think this is an intentional action that clearly violated my right to procedural due process. Interpretations require a written response to ensure fairness and to preserve the right of appeal, to appeal staff decisions and determinations when they appear improper. What is happening here is clearly unfair, and upholding this rejection would violate the standards of reasonableness and consistency required under the law for administrative process. Now, I pray this board will remand the interpretation of these ordinances as they are being applied to this project back to staff and schedule a new hearing as soon as legally possible, providing due notice to all parties in interest, including Silfab Solar and Exeter 7149 Logistics, as the resulting non-discretionary ministerial duty following a correct interpretation of these ordinances may affect them. Compel York County staff to defend their interpretation through the proper process. It has been 427 days since the BZA decision, May 9th, and 104 days since I sought this interpretation. The cost and delay imposed by staff's rejection are unreasonable and unjustified. I've been treated with clear disrespect for simply exercising my right as a resident to seek a zoning interpretation. The staff surely review these provisions before allowing the project to proceed. If the interpretation is defensible, let it be formally stated. If not, let it be corrected. And for those in attendance that share my concerns around this process, I invite you to please stand to demonstrate your support. That's all I have. Thank you again. I'm happy to answer questions. I don't know if you do questions now or later.
Does anyone have questions for the applicant?
It's kind of this time around here at the town says.
After the county speaks, we'll call you back up, may have some questions at that time.
Sit here.
I would just
Go back.
Good evening, members of the board. If you're not familiar with me, my name is Jonathan Buono. I'm the planning director for York County. Just by way of background and apologies in advance, my colleague Josh Reinhardt, who's the acting zoning administrator for the item that's under appeal, couldn't be here tonight due to a family emergency, so you're stuck with just me. So I'm a AICP certified planner. I have 12 years of planning and zoning experience. Prior to being here in York County, I worked in Fairfax County, Virginia, and one of my many roles there, I did strictly zoning code interpretations. That was my sole function. Very large organization, very siloed. So I've done a number of zoning code interpretations. Not my first rodeo, in other words. So came to York County, was assistant planning director for a year. The last 5 years I've been planning director. So enough about me, and I do want to say that anything I'm going to say tonight has nothing to do with the appellant personally, just stating the facts of the case as they are. He's advocating for his rights. We totally can appreciate that. Someone opposing a project and development, that's new, that's time immemorial, right? That's always been the case. But what is generally new is trying to use an administrative process like a zoning code interpretation to backdoor an appeal. So that's kind of the summary of the presentation that the county has. Oops. So here we're specifically appealing the April 11th, 2025 rejection of the zoning code interpretation that the appellant spoke to that he submitted on March 25th. And really the code section that is specifically at issue is 155-1094B. The zoning administrator may deny or reject the request if there is no ambiguity or need for the clarification demonstrated by the applicant. So here are the facts, and I know the appellant spoke about having code references in the prelude to the questions that he posed to staff in the interpretation request. But here are the literal questions, 1 through 3. They were in the packet, you have them, so I won't read them out to you. But you can see that these questions are not seeking clarity on the language that is in the zoning code, and that's important. So for that reason, on April 11th, staff rejected the request based on the fact that none of these submitted questions sought clarification on any provision within the code. So here is that very simple item that is under appeal. I know the appellant talked about a lot of different letters and applications and things like that that are part of the exhibits that he submitted to you all. This is the only matter that's under the board's deliberation today. Just wanted to make that abundantly clear. So sections 155, 1090, and 1091, those are the purpose and applicability sections for a zoning code interpretation, really speak to what the zoning code interpretation is meant to do. And I think it's important, the title of the procedure itself is zoning code interpretation. So just by virtue of the title, that already tells you what the procedure is about, right? We're interpreting the zoning code. The purpose statement here, I'll read this out because I think it's important. A zoning code interpretation is a written decision issued by the zoning administrator regarding the interpretation of any provision set forth in the zoning code. It is intended to clarify ambiguities in the zoning code. Oops, jumped ahead of myself there. So that's deliberate phraseology, that's intentional, it is in the zoning code, and to resolve any ambiguities in future amendments. Now I highlight future amendments because because that tells you if there are ambiguities, and this has happened basically every year, that there's some ambiguity in code, staff will write an interpretation, or there's something that comes up in council, or some developer comes forward and says, I can't do what I wanna do, I can't seem to get around what staff is telling me the code says. Well, how do we fix that? We do a text amendment, right? So we're not addressing a specific project when we talk about zoning code interpretations and resolving any of those ambiguities through a text amendment. If we're talking about a project, that's not gonna be the case. So for the applicability section in 1091, this part applies to requests for a decision by the zoning administrator to interpret a possible ambiguous standard in this chapter. So it's helpful to break down these component parts again because these words are important. We're looking for an ambiguous standard in this chapter. To clarify a standard in this chapter. To clarify conditions of approval pursuant to this chapter. Or to clarify standards approved for special districts. Now, special district is a site-specific rezoning. So it's not a base zoning district, it's a special district. Each district has its own unique set of standards that are outside of the zoning code and can be interpreted in isolation. So what's a standard? They're the requirements or restrictions or procedures. Anything that is in the zoning code is a standard. Now, what are the conditions of approval? And by virtue of what the appellant had submitted and some of the presentation, we're under the impression that he thinks that means how did it come to be that something was approved? And that is, yes.
So I hate to interrupt you, but this is a point when I read through the packet. Because in the packet, they attempt to make the same point that you're making now. And you are attempting to define standards, the word standards, and the phrase conditions of approval. And it seems to me that you're defining them from a professional planner's perspective. But section 155, 600 pages long, the last 40 pages is a section of definitions, which would be, in my view, a great place to define what standards and conditions of approval mean, but neither one of those, that phrase and that word, are not in there.
Of course.
So without it being defined, someone who is not a professional planner sees the term conditions of approval and could see an entirely different definition of that than what you see.
Sure. And anyone could read a word in a professional document, professional planning document like a zoning code. As a layperson, it may not understand as a term of art what that means. Even if it's not defined, universal things like height. You know, the code doesn't define what the word height is, but we kind of know what that means, right? Same thing applies for conditions of approval. So the code is very specific, and it is cited in the staff report that conditions of approval refer to rezoning, special exceptions, variances, zoning compliance, and administrative adjustments. Those are procedures identified in the code that allow for conditions of approval to be applied by the approving body. So in the case of a rezoning, that would be county council. In the case of a special exception or a variance, that's you all. In the case of a zoning compliance or administrative adjustments, that's staff. So it is a term of art. So going back to these questions, again, these questions don't identify a section of the zoning code to interpret, nor do they demonstrate any ambiguity of a standard. The question is not, what does this phrase mean? What do these words mean? Can you explain how this paragraph contradicts that paragraph or maybe another section? That's not the questions that are posed here. They are very specific. The first two are referencing a project. That's a development project that was approved over a year ago, right? So we're not asking what does the zoning code mean and how do I understand it. What we're really asking is how was the zoning code applied to this project when a decision was made about that project over a year ago? That's what those questions are. Third one is a hypothetical. Just by how it's worded, that's not a question about how to interpret the zoning code. Section 155-1094B, it's worth restating. The zoning administrator may deny or reject. So I know the appellant took offense to some of the language that was in the code. It was not meant to describe his submitted appeal, but the reason that this language is in the code is in the event someone submits spurious or nonsensical question, right? So if someone submits, they pay the fee, they submit a document that says, well, I'd like the zoning administrator to explain to me by an official written determination, an interpretation of what height is. Well, we all know what height is. We're not going to interpret that. Or I would like the zoning administrator to opine on why the sun comes up in the morning. We're not going to answer that either. Those are extreme examples. That's not what we're talking about here. In this case, the appellant did not meet the criteria and the threshold of demonstrating that there's an ambiguity in the code that's in need of clarification.
So you say your zoning code interpretations are not an opportunity to revisit or challenge previous decisions?
That's right.
So you're saying that, I'll give you a hypothetical. My neighbor is given a zoning approval. And I believe that it would have been appropriate to apply a condition to that approval, but it was not done. So would it be appropriate for me to inquire as to why a condition was not applied?
So if your question is that type of question a zoning code interpretation? No, that's just a general conversational question that you might ask somebody. That's not a zoning code interpretation. What you're working towards, if, say in your hypothetical, you're unhappy with how an approval got to be, and you wanted a condition of approval to be applied, and you're asking why. Well, you need to ask the approval body why wasn't that applied. That's not a zoning code interpretation. That's asking how a project was approved or got to be approved, or why a specific condition that maybe you were interested in wasn't applied in that case. Now, going that even further, if you wanted to challenge an approval that was granted, the zoning code has a procedure for that, and that's an appeal. That's what you are all doing here tonight. So an appeal was submitted, and that's an entirely separate procedure, and it has time limits on it. So, if your neighbor did that, whatever it is, a project, maybe they built a deck, or maybe it was a commercial business that you happen to be adjacent to, and they got approval 20 years ago, you don't have the right to ask for an interpretation of how that got to be approved 20 years later. There's a time limit in both statute and in our zoning code about how timely your appeal of a decision needs to be.
Okay, but we're just talking about interpretations.
Yes.
So what you're saying is, if that neighbor got approval with a condition, I could ask for clarification about that condition.
Yes.
But if they got approval without conditions and I felt like one should have been applied, I cannot ask for an interpretation as to why it was not applied.
That's good.
My only recourse in that case is the appeal.
Yes, sir.
Okay?
Because absent a condition, there's nothing to interpret. So here is our conclusion. The rejection of the zoning code interpretation request is duly authorized and is a valid procedural response to the request per 1094B of the zoning code. And I should also mention and notify the board that part of the appellant's questions relate to a specific project, and that was subject to an economic development project, and still is. And county council's passed an ordinance, and that ordinance number 6623. That was on September 18th, 2023. So the ordinance, which I'll give to the clerk to add to the record, and it has a FELO agreement that's part of that. It contains a provision in section 5, and that's all ordinances, resolutions, and parts thereof in conflict herewith are, to the extent of such conflict, hereby repealed. This ordinance shall take effect and be in full force from and after its passage by county council. So just wanted to notify the board that for that specific project, the county council has acted legislatively to induce that company to be here. So I just wanted that to be part of the record. So obviously it goes without saying, staff issued the denial. So we're recommending that the board uphold and affirm the April 11th rejection of the zoning code interpretation request. The zoning administrator is duly authorized by section 1094B to deny an interpretation request. So happy to take any questions that you have.
Any questions for staff? Other staff does not return, so if you have questions, now would be it.
I'm happy to be recalled if you need me to.
Thank you. So we will now open the public hearing. We have one person has requested to speak, Mr. Frank Clancy.
I'm gonna yield to, the applicant. I'm not gonna speak today,
Okay.
all right? But I thank you for allowing me to sign up.
All right, so Mr. Lee, would you care to return?
A couple of points. 155.1121, which again, I don't know if, like, what exactly I'm being rejected for, because it was told standards. I had offered to clarify, I had offered to redo it. It's all in there. You can see that the full question. If they had given me the opportunity, I would have, but instead they just rejected me. They mailed it to the wrong address, and honestly, had I not done a constructive denial appeal, I probably wouldn't even have the opportunity to be here because of some kind of date limit. 155.1121 does not explicitly state what the exemptions are. Staff stated that this project was approved over a year ago, and I cannot figure out for the life of me, without a zoning compliance application, how something can be approved. Staff says that I can appeal something, but you can't appeal something if it's not there. And that's the heart of the issue. County staff has made an interpretation. It was explained in the York County Management Statement, and the interpretation is all about the existence of an exemption. And all I'm trying to do is understand how this can all unfold and be in such a way that is completely unappealable. This interpretation, this decision, this quote-unquote approval, how can it exist without an application? And that is the whole substance of these questions, which is, number one, is this a change of use? It sure seems like a change of use from my perspective. Number two is does the zoning code, does it provide an exemption? The 155.1121 just says unless exempted elsewhere. Like, it doesn't list the exemptions, and so it just feels like somebody has misinterpreted the zoning code. And so I just wanted to know from staff, how is this being interpreted? It just doesn't feel like, I'm being told that this is a backdoor of an appeal. I don't feel like I've backdoored anything. I've just asked questions, and the zoning code gives me the right to ask questions. And I do, maybe spurious is a common thing. Even the language that you just used, I didn't ask for the definition of height, and that's just, I asked for how is this being interpreted in this situation, and there is a need, there's a real need here, and I just feel like I'm within my right The fact that I'm not a part of the project. This county has already done a zoning interpretation for somebody on this project that wasn't part of the project to begin with. And so now I'm just treated differently than everybody apparently. And it feels incredibly unfair. It feels unfair that they only bring up standards while I am, and then now it's all of these other things. After I've spent all of this time, it's been 100+ days, mailed to the wrong address. I received 2 incomplete letters because my appeal wasn't complete enough, or it was too complete. And I just don't think that I've been treated fairly, and I really hope that this board understands that, and I hope that you don't uphold this review. So,
I got a question.
sure.
Are your concerns limited to this specific project, or are you raising broader concerns about how zoning procedures are interpreted and applied in your county?
Yeah, so that's a really good question. So certainly I would hope that this never happens again, right? I think it seems as if the conditions of this project related to a FILO agreement that staff just brings up, that has nothing to do with zoning. We were at those meetings and we were told by council that has nothing to do with zoning. And so for all of a sudden, this is a supposed exemption. Why isn't it listed in the zoning code? The applicability just says except exempt elsewhere. It doesn't state what the exemptions are. You have to go and find that vested rights ordinance. In the vested rights ordinance, then I refer back to the I forget the code, the 153 code, right, which clearly defines vested rights, and it says no. It says number 1 that it has to be a zoning administrator approval, which again I don't see where the zoning administrator approved it. So, and staff saying it was approved a year ago, I just don't know by who. And again, you go to a South Carolina ordinance and it says the only person that can, and I don't know if I can pull it up, but it's somewhere in my presentation. It says that it's unlawful for other officials to give an approval that are not the zoning administrator. And so it all feels weird to me. And so yeah, I absolutely feel like there are examples that I provided in FOIA that are specific examples. They're saying, hey, how do you interpret this code, right? And it's like non-conforming use things. It's things that are outside of that applicability that staff is pointing to for my case. And I'm sorry, I've lost my train of thought there, but so I do think that after these kind of things happen, it gives the chance for staff to do more than just explain or provide definitions, but to actually look at that code and say, hey, it says unless exempted elsewhere, we don't list where the exemptions are, right? And so there has been a decision by somebody about this being exempted, this project being exempted from something. Exempted from the BZA decision, exempted from even having to apply with a zoning compliance application. I'm just trying to ask where and how did you interpret these? That's all. So, I don't know if that answered your question.
Oh, I was just going to say, I was waiting for you to fully answer it, honestly.
Sorry.
Yeah, so you asked you if it was for this specific project or in general. So that was
I mean,
you answered that
the questions, the conditions were about this project, right? And like I said, in the FOIA examples, it's not like this is the general question department, right? The examples are like, hey, my property, I think is a non-conforming use, I'd like to do X, Y, Z, blah, 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 right? Like there's specific examples that come forward with an interpretation. It's not like, what did you mean by height? And so, yes, I do think that these questions are pertinent to this, but I do think they are applicable to other things in the future. Did that help?
It seems to me you are requesting from staff how code was applied in a particular case.
Yes.
But the ordinance gives you the opportunity to ask what a zoning ordinance actually states, the meaning of the ordinance. What you want is its application, but what the ordinance gives you is its meaning.
again, I see others asking for interpretation related to specific situations. They aren't asking what the words are, they're asking how is it being interpreted. And there's been an interpretation here in terms of the code. It's not the definitions, right? It is a broader interpretation. And so that is the question. How has this zoning code been interpreted? And it feels like it is a fair question to ask.
So you were told that, or I don't know if you were told, I guess I'm rejecting that, but you said that, I believe you said you never received anything for clarification. Can you explain that a little bit more?
Yes.
What that process was, what you heard, what you didn't hear?
Sure. So first is I emailed the development director and the FOIA officer.
Yeah, and specifically, I was talking about, you have like those questions that they're asserting that are totally different.
Yeah.
Well,
Maybe I don't understand.
no, meaning there's certain that don't go just against or about the code itself, that were more specific to a project and everything else. I guess that outside of that, the process back and forth for anyone asking you for clarification, or you offering that
Right,
clarification,
right.
that process, tell me about what happened there.
So this began with first the record keeping question. I'd like to see the zoning compliance application. And in that, I also asked the question, some questions, just some general questions. Staff came back and only responded to the freedom of information question. They didn't acknowledge my initial questions. Now, the zoning code, which is all I had to work with, doesn't say anything about an interpretation application. I go to the county website, and there is no interpretation application. I did not know there was even an interpretation application. So staff came back to me and brought in the FOIA officer, and I said, hey, this is also an interpretation question. I'm asking a question here. And staff ignored that question again, only referring back to my freedom of information question. Then I spoke to an attorney, I paid money, and the attorney pulled up on her computer, and she said, no, I think there's a form. Goes on the website, there's no form. So she's like, okay, well, she helped me kind of rephrase these questions, because I think maybe mine were a little rough, but again, I didn't get any kind of response. And so I worked with her, and she said, go down there. So I went down, and I brought the questions to a zoning technician, and I said, this is my questions, right? Takes my money, takes the application. I said, is it complete? She said, yes, it's complete. And then I go home, I wait 3 weeks, I start emailing. I don't know that they're supposed to respond. I start emailing, I start calling, and I did not get any response from anybody. So I called that lawyer again, and she said, you should file an appeal as a constructive denial. Basically, they're not answering your interpretation question. And so I did that. And then 10 days goes by, and I get an email saying that it had been rejected. And that's standards only. It's not trying to figure out which part of the code, it's nothing. Not trying to clarify my question at all. And then I ended up redoing my appeal a second time. And because they said, hey, this first one's no good because we gave you this rejection letter, so you have to specifically talk about these points. And so I went back and I took their response, my incomplete letter, and I started reworking it, the appeal. And then I put it in again. And then 10 days later, I get another incomplete letter because it included things that, like I included that first incomplete letter, and I guess you're not supposed to do that. And so I just, eventually I was just desperate to be heard by you all. I contacted my elected officials. I started calling people in the state government, and I basically was looking at this law that says that they're supposed to immediately provide this appeal to you all immediately. That's what the code says. And they weren't doing it. They weren't giving it to you. And so eventually, I finally got a letter saying that it was complete. And then I waited here, but it's been 100+ days since the formal one. Add another 15, 20 days since I sent that email to ask these questions. And nobody told me this isn't an interpretation until now. Like I said, this feels like the zoning code has been interpreted. It doesn't feel like it's been interpreted correctly in this situation. And all I'm asking for is, well, how did you interpret it? And again, I guess I'm just confused in terms of like, what counts now? Because other people got interpretations about specific projects and things like that. To me, ambiguity it's ambiguous, right? Like, somebody's interpreting it one way, which is the staff. I am interpreting it another way. And my interpretation of the zoning code as it relates to this project doesn't count, apparently. I don't know why.
You'd mentioned a couple times that there have been others that had interpretations, done. Can you give us some examples?
They're in the Exhibit 1. So even though this is supposed to be public record and you're supposed to be able to get it in due time, they put me through a FOIA process, and then they wait 10 days to respond to me, and then they wait until 30 days, which is probably like the last legal limit to actually get a response. So I didn't get to see what the responses are. Maybe in 10 days I'll get it. I don't know. But these are examples of people's other interpretation. And again, this was me responding to just standards. And to your point, Ms. Blair, standards aren't defined in the zoning. And I'm not AI, CP, whatever. I'm just a guy. And so I'm just looking at this, thinking, hey, how is this all happening around me? My property's right there. My children live with me. This doesn't seem like it's been interpreted correctly. Why can't I seek an interpretation? This code says that I can anybody about anything, and I think the reason that it gives such broad availability and accessibility is for the fact that sometimes staff can interpret the code incorrectly. I think that the staff has interpreted the code incorrectly, and it affects me. And I should be able to ask a question. And this project is not received final zoning compliance approval, right? Like this whole 20 years ago thing, this is not the case. This is an active development. It's a troubled development, a very troubled development. And I just simply asked a question. And now I'm being accused of backdooring an appeal when there is literally nothing to appeal in the first place.
Any more questions for the applicant?
Not at this time.
So I'm sure you're familiar with some of the boards, 155, 1093, and 1094. Both of them state that the zoning administrator may deny or reject. And in the approval criteria, it says the zoning administrator may approve or the zoning administrator may deny. How do you deal with that? It seems pretty cut and dry to me that
So
whether or
I
not
don't know how you approve an interpretation. Is like that just kind of feels weird to me. Approve an interpretation. Somebody's asking, how does this apply?
It's an approval of the interpretation request, not the interpretation itself.
Oh, okay, I see. So yeah, they can approve it and do it, or they can deny it, in which case they have to provide a written response. Their response was, only standards may be interpreted. And that does not sound right to me, and so I spent $325 and another 60 some odd days to be heard in front of you, when if it could have been an email, I would have loved for it to be an email.
So the 1093 just says the zoning administrator may deny or reject the request in writing to the applicant that shall be delivered by regular mail.
Mm-hmm.
And the approval criteria says may deny or reject if there is no ambiguity or need for the clarification demonstrated to the applicant.
Yeah.
So it doesn't actually say that they need to provide any explanation for the denial. They could just send you a letter that said denied.
Yeah, which they sent to the wrong address. But yeah, I supposedly yes, they can do that, and that gives me the right to appeal that to show you all that there is a need for interpretation here. There seems to be an ambiguity in terms of how this zoning code is being interpreted by staff. And when I look at zoning code interpretation, that means that staff creates an interpretation of the zoning code. They look at those words and they say, what do these words have? And what do these words say? And what do these words mean? And then they have a duty to do it. And so, from my perspective, there's kind of two options here. And the first option is they have misinterpreted the code. From the York County Management Statement, it sure seems like they have misinterpreted what counts as exemptions in the code. The exemptions aren't listed in this code. The other option is the far more nefarious option, which I hope isn't the case. And again, I don't know. That's really all that I can say at this point. And they may do things, right? That's a may. But what I showed you in these ordinances was a whole bunch of shalls. And that's what I'm struggling to understand, how these shalls have been applied.
I have a question, just out of curiosity. When you received this letter, 'cause it seems like you've been going back and forth, maybe with staff,
Mostly fourth.
Did you consider, before coming to the Board of Zoning Appeals for appeal or anything, maybe trying to resubmit and removing some of the ambiguous language that they cited, or like did you consider going more towards the standards since that's what they cited to get an answer to your question?
They literally just said standards, and the application says, and then even in their response they list oh, there's a bunch of standards, and then now they're saying, well, everything's a standard. Again, I'm not a zoning guy. When I see standards in one rejection, and then I see any section, to me it seems like they've tried to limit the scope, right, to just standards. Then I FOIA and I get this other stuff, basically, because I was thinking, well, maybe because I'm in the procedures section, that it doesn't count as an interpretation because it's just procedures. But that's when I got the FOIA and I see other people doing interpretation questions of their situations. How would the zoning administrator interpret this situation? That's what I'm seeing, and so I was like, okay, well, why can't I ask this question formally, right? Because right now we have something that's informal. An informal interpretation has happened that they don't feel like they have to defend.
I got a question. So if the board chooses not to issue an interpretation or to reverse the staff decision, what alternative remedy or action you hoping the county will take to address your concerns?
If the board,
If we choose not to issue an interpretation.
well, I don't
reverse
think you
staff-
can at this point. They've kind of reframed the appeal, so this is just, do I have the right for an interpretation? That's what they've now changed the question. You'll see that in kind of earlier in the pack. That I had originally just said, well, gee, can't somebody just interpret it? Like that's literally all I want. I'm not trying to, if I'm not saying stop this project, I'm not saying those things. All I'm saying is interpret the code so that it is an appealable and questionable, so it can come to the board to see if these exemptions exist. Like that's really all that I've asked. And again, because my appeal now has kind of like morphed down this line through various incomplete letters, and here I am, so it might not be fully the relief I sought fully, but in my presentation, which is basically, can you remand this back to staff to say, how did you interpret the code? How did you interpret these ordinances as they apply? Like, that's kind of just what I'm asking, and maybe it should have been a phone call. And again, this was pushed out in an unappealable, unquestionable way. And it seems as if you kind of make this determination that people can't ask how the zoning code has been interpreted, if your neighbor wants to do something that you think is not against the zoning code, they can just kind of figure out a way to get it done, and you can't even ask the zoning administrator, like, why didn't this apply? How didn't you? And then, yeah, maybe you can appeal it, but again, there's literally nothing to appeal, which is part of the questions, right? Is this a change of use? And is this, if it's a change of use, then it requires a zoning compliance application. There is no zoning compliance application. There's literally nothing to appeal. And keep saying that it's been approved a year ago, and I don't know where it's been approved by the zoning administrator, which is unlawful. And I just don't understand how we can just ignore that, I guess, is my question. I feel like somewhere along the way, if I were to ask these questions to a zoning administrator, in a real world where zoning administrator doesn't know my neighbor, know me, they would answer my question, and then they might look at that thing and say, oh, you're right. This doesn't have a zoning compliance application. I do have to do this. But this isn't a perfect world, apparently, and now I feel like I'm defending my right to ask a question where I feel like it's in the code that I have a right to ask the question. And I know this puts y'all on the spot. I get it.
Any more questions for the applicant? Thank you.
I have a question for the county.
Thank you.
What's the procedure from the county in terms of responses to the zoning code interpretation request? Is there a timeline that you're obligated to meet so that as a county resident, you can expect a response within a certain amount of time, or is just
Yeah, there's a procedure section.
Well, what is that? Can you tell me?
No, not off the top of my head, ma'am, I'm sorry.
Chapter E.
So if I file a request as a county citizen, I don't have an expectation of a response within 30, 60, 90 days or anything?
So there's a completeness review for any application. I believe that's 10 days. And so, once they have an opportunity to address any deficiencies in the application, that's when it gets scheduled for the board.
And that's when the calendar starts?
The calendar
For your timelines? Is it when y'all respond to the applicant, or is it when you receive it? I saw the one that was like date stamped March, whatever the original letter was received.
So whenever we receive the application, that starts the clock for us to conduct the completeness review for 10 days. So, you all just meet once a month and it's a dedicated date. So once we have the application, it's deemed complete. If it's timely, because we've got to draft a staff report, those take time to analyze those, review those, and edit those. Then it gets put on the next available document.
And how many of these zoning code interpretation requests do you receive a year?
Handful, maybe a dozen or so.
Do you know off the top of your head how many get approved?
Yeah, and so maybe a good example is the one that you all had that came to an appeal from Mr. Buchanan last year, that case. So he had submitted a list of 7 questions for interpretation. Staff rejected 5 of those as they don't meet this standard that we need to answer them. 2 of them, I said, yeah, okay, that's could be ambiguous, we'll answer those. And the applicant for that interpretation accepted one of those and appealed the remaining. So that's an example. Typically, when someone is applying for a zoning code interpretation, they have a development project that they would like to have come to fruition, and they want to know how to make that happen, which is very atypical. I did not see it in my previous jurisdiction experience, and this is the second time I'm seeing it here. The more atypical is someone not affiliated with a project asking for a zoning code interpretation as a means to try to challenge that development that they otherwise oppose.
When you deny a zoning application, usually it'll state, based on these reasons, or they'll specify a code, the whatever the rulings are. When you approve an application, do you also say, based on zoning code A, B, C, and D, we're approving your application?
So when we approve a zoning code interpretation, there's not an approval letter that says we approve your zoning code interpretation, right? We approve the request and we respond with an affirmative answer.
I'm going back to the original application for I want to open up a hair salon in my backyard, and I apply for an application to convert this shed to a hair salon.
Yep.
You approve it. Do you say, based on zoning code A, B, C, and D, your application has been approved? Because I know you would say, based on A, B, C, and D, your application has been denied.
Right, so we have software for people to submit through a web portal, and we review it, it's called Evolve. So a lot of the exhibits you'll see has it evolved in there. So the applicant, when they apply for something, whatever it is that they're applying for, they submit it into the web portal, it goes out to the responsive reviewers. In this case, as it relates to all of you, it's a zoning reviewer that's on the other end of that. They provide their comments, and then once that review is done by all of the required reviewers, whether it's building, fire, because it goes beyond zoning for any application, honestly. Once all of those comments are done, that letter is issued to the applicant. Says, okay, well, they were approved per the fire comments, they were approved per building, denied by zoning for X, Y, Z reasons, denied by transportation for X, Y, Z reasons. It lists the items that need to be corrected before it can be approved.
I thought you had another, I thought you had another question.
Oh, no.
Okay.
I may in a minute.
Okay, so let me ask this question. The applicant states that the zoning interpretation was mailed to the wrong address and received late. Does staff acknowledge this error? And if so, how does it affect the timeliness and the fairness of this process?
So yeah, we misread the handwriting, 8 for a 0. So yeah, we acknowledge that we mailed it to the wrong address. That's just the number that we read off. Nothing nefarious or intentional there. It's just handwriting, reading the handwriting, clerical error. And no, the appellant in this case has not lost any opportunity other than he received the denial letter later than he would have had we put the right address number in there. So he's not lost anything, no opportunity to come before you all because
Anna, I think you answered this. I didn't hear the answer. Well, I answered this question, but I'm gonna ask it again, just to make sure I got full understanding. If a citizen believes a procedural error or misapplication has occurred, and it falls outside the scope of zoning interpretation, what form of remedies are available to them?
yes, there's a separate procedure section for appeals. So that's the procedure that the appellant took to get before you all.
Okay. And I think Ashley sort of asked this, but I'm kind of asking in a different way. Have there been any prior cases in York County where zoning interpretation was granted or considered for procedural issues rather than development standards? And if so, how were those handled?
Not sure I follow your question precisely, but I'll try to answer it and see if I hit the mark. So sometimes someone will submit a zoning code interpretation that says, well, I think based on our use of the property and per the non-conforming section of the code, and also the code section, I think we meet the criteria for grandfather, essentially. I think that's one of the exhibits that the appellant attached as an exhibit. And so we would answer that question because they're asking, well, here there's a set of criteria for our use to be non-conforming. They describe to us the specific conditions under which their property is currently operating. And we say, well, based on your description, that either is or isn't considered legal non-conforming in the code. So that's a legal interpretation of the evidence that they provide supporting whether it's non-conforming or not versus our reading of the code and interpreting how that should be applied.
Listening to Mr. Lee, it sounds like there was a lot of, I think this happens a lot with any government agency in Europe, just a lay person like myself, be confused where to go. So this is kind of the direction where that's coming from. I just wanted to have an answer to this. So given any project, right, and let's say just any project you look at, if something's happened, and there's been some compliance put towards it evidently, but you can't find any interpretation or any compliance documents on that, and you've answered this, right? You've asked questions, and evidently the questions aren't to standards, right? What is the process that you would allow somebody to tell them, hey, listen, this is the process, you need to go through a different process? I'm hearing, and so correct me or explain to me, that there's a process to appeal if there is a zoning compliance form filled out and completed, but if there isn't one, what is the process that you would tell any of us to go to, including myself? I mean, if I wanted to ask these sort of questions, you're saying it doesn't go towards the standards, where do I go with these questions?
Right. So when you apply for a zoning code interpretation, you're asking for an official written determination, right? And that's a twofold purpose. One, you get a definitive answer. It's in paper. Nobody's going to be like, oh, just kidding. We had a phone conversation, and this is what I heard. It's in writing, right? The second function is it allows that individual to appeal, saying, well, this interpretation is incorrect, right? So we've had a number of those throughout the years. That's just what the function of that is to get that in writing. And when it comes to zoning code compliance, I think there's a process, confusion, conflation, misunderstanding about what zoning compliance is. So if you are applying for a project in York County and it has zoning review attached to your process, your application in Evolve when you submit in our online portal, the zoning reviewer is the zoning compliance on that project, right? They don't fill out a separate application for zoning compliance for review of a project. The zoning reviewer is reviewing the zoning code for that project's compliance with the zoning code. That's their function. They're a duly authorized representative of the zoning administrator in that function. That's their duty, that's their job. So the zoning code says zoning administrator. That's the person that's responsible, that's the person that's liable, that's the person that's accountable. That doesn't mean that one individual is literally making every decision that the county ever makes regarding zoning. So we do have duly authorized staff that review projects, whether it's a subdivision, it's a commercial project, anything that zoning touches, there is a reviewer, and that comment, approval, denial, whatever it is, that's the zoning compliance of that project. So I think there's some misunderstanding about what a zoning compliance is when you have a project that has more reviews other than just zoning.
We've heard the term zoning compliance letter. So you're saying there is no such thing as a zoning compliance letter application?
So there is a zoning compliance application, but again, that is used for projects that have no other review attached to it. So they fill out a zoning compliance application. They say this is what I'm applying for, and then the zoning reviewer is going to review that for compliance with the zoning code. Perfect example is home occupation, right? So I have a home, and I want to open up a small business, and I want it to be in my garage. I apply for it. No one else is looking at that because nothing else applies. It's just zoning. So it's a zoning compliance application. So you know, in reference, and it's outside the scope of the discussion, so I hate to bring it up, but the project that's referenced in the appeal by the appellant had zoning compliance approval by virtue of the civil construction plans that were approved in April 2024. So if there's confusion about that, that is the decision. The zoning compliance for that project was zoning's approval of the civil construction plan.
So a question about this 155-109 village reference here. Section B, it says the zoning administrator may deny or reject request if there's no ambiguity or need for clarification demonstrated to the applicant. And we have actually two letters here, and both of them are actually the 1093 says it has to be delivered by regular mail, so I assume that this was, but both of them are signed by the development services manager, not the zoning administrator.
That's correct. The position of zoning administrator was vacant at that time.
So is there an officially acting zoning administrator?
Yes, the development services manager is the acting zoning administrator during the time of that vacancy.
And the other thing, you know, this becomes a, you know, the word ambiguity is used here, and I can tell you from being on the planning commission for, I can't remember how many years, and on this board of appeals for, I can't remember how many years, there is massive ambiguity in the zoning code. It might be the most ambiguous thing I've ever read 600 pages of. So it becomes a question of, to whom is it ambiguous?
Of course.
To the people that wrote it, they know what they believe, but do they know what they wrote? And to the people who read it, it's enormously ambiguous. So, I mean, the section says zoning administrator may deny if there is no ambiguity, but there wouldn't be an application if there wasn't at least ambiguity on somebody's part.
Well, I think it's important that that language is in there that allows the zoning administrator to deny an application for zoning code interpretation request. To extrapolate your answer would be to, your question I should say, would be to suggest that if anyone alleges that something is ambiguous to them personally, that we are automatically therefore obligated to answer that question because they personally feel like it's ambiguous to them. The burden is on the appellant to prove to staff that there is an ambiguity or something in need of clarification. That's clear in the code. It says they must demonstrate that. It's not that they personally feel like there's an ambiguity. They have to demonstrate that ambiguity.
A demonstrated ambiguity to one person is not a demonstrated ambiguity to another. There's a lot of room for improvement in the code, I can tell you. Any more questions for staff? Well, thank you. So, the applicant has asked 3 questions. Whether or not we uphold his appeal is really determined by each individual question. So, I feel we would be better if we proceeded with a motion on each question. So, I would phrase it like this. Did staff err in denying the requested interpretation regarding question 1? And we will need a motion to either uphold staff's decision staff errors in the decision?
I make a motion to affirm staff's decision in the rejection of the zoning interpretation in regards to question 1.
I will second. We have a motion and a second. Any discussion?
The motion is to affirm staff's decision regarding the
Yes.
change in use.
I think, based on the conversation we've had, I think a lot of these questions, I don't think it's just this one in particular, even though this is the one we're talking about. I think just looking at the questions that were asked, I can't see how a clear ambiguity, and I know we're using that word over and over, and what it means to certain people, and what certain words mean, regardless of like if you're in the planning profession or not. But I think, based on this question, specifically the first question, I don't see how there was clearly an expressed need for clarification that was demonstrated by the specific question.
I will say that I feel that we have a difference between the applicant and the county in the interpretation of the purpose of the interpretation request. That the applicant wants an interpretation of how the code was applied. That the county's obligation, if they choose to take it, is to give an interpretation of the text of the ordinance. And those two are quite different. Any further discussion? All those in favor of the motion to uphold the decision of staff on question 1, signify by raising your right hand. Opposed? Vote is 3-2. So regarding question 2, same thing. Did staff err in denying the requested interpretation in regard to question 2? I need a motion in regard to question 2. I'll make a motion to uphold the decision of staff.
Second.
A motion and a second. Any discussion?
I think, for me, it goes back to the same thing as question 1, if not even more unclear as to what need for interpretation was there. Very broadly, it's asking about an exemption and final zoning compliance without reference to a specific area of the code, at least what I'm looking at currently. And it goes back to my same point on the first one, is that you're not asking a clear question about, clarification on the code. You're asking about a specific incident and a past decision that was made, which has its own process. But I think when it comes to the specific letter, that I agree with staff's decision, based on this question, to deny the zoning interpretation request.
Same thing. I agree. Mr. Lee asked very good questions, but they're not questions within the scope of the zoning code interpretation request. Any further discussion? All those in favor of the motion to uphold the decision of staff, signify by raising your right hand. Opposed? It's 3-2. Motion carries. Question 3, did staff err in denying the requested interpretation regarding question 3? We need a motion.
I make a motion to affirm staff's decision to deny the zoning interpretation request in regards to question 3.
I'll second. Any discussion?
Point's been reiterated. I think this of the 3 is probably the broadest in scope and the least honestly the least cited need for clarification out of the three questions. I think it was confusing to even read and kind of understand what the question was getting at, and I think when you get to that point, then it is quite obvious, to me, at least in my opinion, that it's a very ambiguous question, or not specific to a specific point in the ordinance, and there's no need for clarification on that question.
And my logic is the same as questions 1 and 2. Any further discussion? All those in favor of the motion to uphold the decision of staff, signify by raising your right hand. Opposed? Motion carries 3-2. We now need a motion to enter executive session to receive additional legal advice, I believe unrelated to this particular application.
I'll make a motion.
Motion, do we have a second?
Second.
Motion is second, any discussion? All those in favor, signify by raising your right hand. Right, motion carries. Back we go. executive session. The board only entered executive session to receive legal advice, and no action was taken during the executive session. The next agenda item is adjournment. Do we have a motion to adjourn?
I make a motion to adjourn.
Second. All those in favor, signal you ready. We are adjourned.